Hello, I'm Andrea Morgan with the Morgan Divorce Law Firm. Welcome to my fireside chat. Today I'd like to share with you some insight about equal marriage and equal divorce. First off, if you're a member of the LGBT community, I want to congratulate you on your hard-fought battle for the right to marry in Florida. Your perseverance finally paid off in 2015, proving that love does in fact win. It should follow that if you are dissolving your same-sex marriage in Florida, your rights under Florida divorce law should be equal to those of a straight couple getting divorced, right? The unfortunate answer is that is not entirely the case. Not yet anyway. Here's the reality. In some areas, which we will discuss today, divorce legislation in Florida has not yet caught up with the realities same-sex couples face when they decide to part ways as a married couple. As a divorce attorney here in Orlando who represents members of the LGBT community, I'd like to share with you my thoughts about where I believe the law does not apply equally to you. There are three important subjects we are going to address today. The first is what is known as the equitable distribution of your marital assets and liabilities, which is just a fancy way of saying when you get divorced, you and your spouse have to divvy up the property you own together, as well as figure out how you will pay back the debt that you incurred together. Equitably, under the statute, has been interpreted as fairly. I can say generally, this usually means each spouse will receive 50% of the value of a marital asset and 50% of the responsibility for a marital debt. A critical factor in Florida's equitable distribution statute is that marital assets and debts are calculated as beginning from the date of the parties' marriage. This means that all assets and debts acquired by you or your spouse, beginning from the date of your marriage, must be divided between you, either by agreement or, in the absence of such an agreement, by the court. For LGBT members living as a married couple before they were legally permitted to marry in 2015, the date of the marriage language part of the equation can create an unfair and thus unequitable property division between same-sex spouses in a court of law. Keep in mind that judges must apply Florida law as it is presently written. A judge's hands are literally tied to do otherwise, even if he or she sees that such a decision would be unfair. Consider, for example, that your now spouse, whom you have been in a committed relationship with for many years before your marriage, purchased $1 million piece of real estate before you were allowed to be married in 2015, and you were never placed on the deed. This real estate would be considered non-marital property under the Florida statutes. Thus, you would be completely excluded from any division of this asset.
I, the undersigned, shall forfeit all rights, privileges, and licenses herein and herein contained, etc., etc.
Contrast this result with a straight couple who have been together for the same amount of years as you and your now spouse. The only difference is that the straight couple had the right to marry for the entire time they were a couple. In this instance, the straight spouse would be entitled to an equitable distribution of this asset, which would be generally calculated as 50% of its value.
Hey!
On the other hand, you are out half of the property equity because you were not allowed to be married in Florida until 2015. Alimony is a second area that gets complicated in LGBT marriages where you and your spouse were together for many years before you were given the legal right to marry. A critical area in determining alimony is the length of your marriage. In Florida, a short-term marriage is from 1 to 6 years, for which there is no presumption of alimony. A marriage of 7 to 16 years is a mid-term marriage for which durational alimony usually applies, meaning alimony for a set amount of years. A marriage of 17 years or more is considered a long-term marriage for which there is a legal presumption of permanent alimony. So, if you are divorcing today, what happens if you were in a committed relationship with your spouse for 10 years before you were given the legal right to marry in 2015? The black letter law today would conclude you were married less than 7 years, and therefore there would be no legal presumption for an award of alimony. The third area of impact, if you are in a same-sex spouse divorcing, involves your children, if you have them. The laws of parentage are in flux right now because of the infancy of marriage equality. But let's say, for example, your spouse is the biological parent of your child or children. If there is a custody battle in your divorce, you can expect your spouse to claim he or she has superior custody rights over you as the non-biological co-parent. And this is especially true where you have not legally adopted your child or children. It is unfortunate that when a same-sex marriage ends badly, the spouse that has something to gain will often use laws which produce discriminatory results to their advantage. I have much empathy for my LGBT brothers and sisters for this sad fact. There are ways, however, to end your same-sex marriage where considerations of equity and fairness can be accessed for best results. I hope this information has been helpful to you. If you have any questions about what we've discussed today, feel free to reach out to me at the contact information on the screen. I'm Andrea Morgan with the Morgan Divorce Law Firm. Who's in your corner?